Morning, everyone. Welcome to the Recruitment Directors Lunch Club webinar. My name's Barney Lawrence. I'm here with Mark Fellows. We're both partners in the law firm of Sherrards. We specialise in the recruitment sector, so we know your sector back to front. And the topic we're going to be talking about today is restrictive covenants. And for those of you who may not know, restrictive covenants are clauses in your contracts of employment with your staff which say that for a period of time after they cease to work for you, they can't do certain things such as contact your clients, solicit away your staff members, even go so far as to stop them from working in competition with you altogether. So what we're looking at is the legal regime by which members of staff can be restricted from competing with you after they've left your employment. Now, it's a widespread misconception that restrictive covenants in employment contracts are not worth the paper they're written on. That's often what people say, and I always point out that that's just not the case. And we're going to hopefully come on to explain and clarify for you why we say that. And it all starts with the employment contract.
So it's an obvious point, but there are some clients of ours, some businesses out there that don't have contracts in place. So it's a fundamental need in a business to make sure that that contract is in place, that it contains a confidentiality provision dealing with confidentiality during employment and post, an intellectual property provision that deals with who owns IP generated during the employment. And then finally, of course, what's most relevant to us today is the post-termination restrictions. Some of my clients use a separate document that they call a covenant deed that contains all of the post-termination restrictions, and it's a sort of a separate standalone document. I personally don't like those. There's a risk that that will get lost and that there'll be difficulty proving it was sent to the individual. I'm much more in favour of just having it all contained in an employment contract that is signed, and that's the other obvious point here, and it may seem obvious to you guys, but there are lots of businesses out there that don't get signed contract back from the employee. And that is a concern because it gives the individual at least an opportunity to argue that they're not bound by those restrictions. And Barney will talk about that in a moment. But there were two key messages in respect of the employment contract is don't assume once you put that in place that it's job done, because particularly in recruitment, particularly people who get promoted as they go along from junior consultant to senior consultant, you have to revisit the restrictions to make sure they're still fit for purpose. Some clauses that restrict for 3 months may no longer be suitable for somebody who's now a very senior person in the organisation. So when you're promoting somebody, you're giving them that hefty pay rise, it's actually a good opportunity to revisit the restrictions and get them to sign up to more onerous and relevant restrictions at that point. And also do bear in mind that if you haven't got restrictions in contracts at the moment for certain staff, you can introduce them during employment. It's not like you've missed the opportunity. There is always scope to ask an employee to enter into a revised employment contract that contains restrictions.
Just picking up on the point that you raised there, Mark, about keeping the covenants under review as your staff progress the business. I'm dealing with a case at the moment where a client is being faced with action in relation to restrictive covenants that he signed up to 18 years ago when he was a starter at the firm. He's now the managing director of that firm, but the covenants were never reviewed throughout his time there. And whilst those covenants were, whilst when he entered into those covenants 18 years ago, they might be enforceable against him today, but in fact they weren't entered into today, they were entered into 18 years ago. So that's likely to avail him as a defence. But you also touched on the point about signing the contracts, and often what happens is you write to an employee when you know that they're up to no good, and they leap at the opportunity to point out that they never signed the contract. We never signed it. Produce a copy that we signed. We're not bound by that. Actually, that's not the end of the story. If you can demonstrate that you, for example, sent the contract to them by email or on the cover of a letter, that they received it and that they acted in accordance with its terms, then their actions in doing so will likely deem them to be bound by the terms of the contract. So it's not essential that they sign the contract, but as a matter of best practice, it is absolutely the best way forward.
And then we often get asked, well, what happens if we don't have post-termination restrictions in place? What right of recourse do we have as an employer? If the person's still employed and the relationship's working perfectly well, then as I say, you can introduce them, and it's actually effectively a change to their terms and conditions. And there is case law that if an employee refuses to accept post-termination restrictions that are legitimate, that are reasonable, it can actually provide the employer with the right to terminate as an extreme course of action. But it's the basis upon which you can push those through. So don't think you've missed that opportunity. But obviously, you need to be careful about how you go about doing that, because of course, asking an employee to sign up to restrictions that they're not currently subject to will make them very nervous, will make them very suspicious, but it is achievable. But the problem arises if there aren't any post-termination restrictions in place and the relationships come to an end. Often it's an acrimonious end, it all goes very sour. Unfortunately, the reality is that you as an employer are going to be very limited recourse, because without those restrictions, the employee not only has the right to go and work for one of your competitors, they also have the right to go and seek and solicit your clients without normally any repercussion. The only caveat to that, and the only thing that might provide you with some protection, is in relation to confidentiality, and Barney will talk about that.
Yeah, confidential information. So if you find yourself in a situation where you haven't got any restrictive covenants in your contracts, it's not necessarily the end of the road for you. What often happens, particularly in recruitment, I'm not sure why, but it does happen a lot in recruitment, we see it all the time, is that an example being 2 days before the employee leaves, they download a copy of your database onto a memory stick, and they go there, they move on to their new firm, and they make use of that. Now, you can enforce the confidentiality rights against that employee, irrespective of whether they've got any restrictive covenants in their contract. Okay. And what the court will do in those circumstances will grant an injunction preventing them from making use of that database, for example. And the length of that injunction is often viewed as the time it would have taken that employee to have compiled that database by legitimate means. So the judge will say, well, if after he'd left your employment, he'd started to accrue a database, how long would that have taken him? And if that would have been 6 months or a year, then the injunction will typically stop them, keep them out of the market for that period of time. So that's a powerful provision in your favour, irrespective of whether you've got restrictive covenants.
So the next question is, you've got the employment contract and you've got the restrictions, but is that enough? Well, the key actually is making sure that those restrictive covenants will work, because the last thing that you want to happen is you get in touch with us and you say, I've got this problem, this employee's competing, and we say, well, have you got restrictions? You say, yeah, here they are. And we take a look at them and we say, oh, we actually don't think you're going to be able to enforce them because they're not drafted appropriately. The key message, and it's not an attempt to sell, but the key message is don't do it yourself, because invariably that's where the problems arise. There's a temptation, certainly a lot of our clients will pull various clauses off from the internet that they've seen, they'll merge them together, and they'll take the view that that will be satisfactory. Unfortunately, because these clauses are viewed, they're scrutinised by the courts, they have to be absolutely right. And also, you need to avoid, in our experience, a one-size-fits-all approach. They do need to be tailored to the individual and their responsibility and their seniority.
Yeah, so just to interject there, where you might have a junior employee, it may be appropriate to restrict them from competing with you for 6 months. But if it's the managing director of the business who's been at the forefront of the business, knows the clients inside out, knows the pricing structures inside out, it may be more appropriate to restrict that person for more like a year, or sometimes in certain circumstances, even longer than that.
Yeah, and that's actually one of the key points I wanted to mention in terms of some things that you can take away when it comes to these clauses. Number one is the length of the restriction. There's a temptation to say, well, we'll restrict the person for as long as we can get away with. But again, the courts don't like that. It's not a case of just saying, well, we'll give it 12 months and that'll do it. You actually do need to apply your mind to how long you actually need. And that's because these clauses should go no further than absolutely necessary to protect the interest in question. And the legitimate business interest usually is confidential information, it's trade connections, your connections with your clients, and your staff as well. We're obviously trying to protect your staff from being poached. So when it comes to the length of restriction, actually ask yourself, how long do I need to have that person out of action for, so that I can step in and salvage the relationship with a particular client in question. Second good tip is link the person who you're restricting to dealings with the client. So again, there's a temptation to say, well, I'll just stop him having any post-termination dealings with any client of my business. And the problem there is courts don't like that. The courts would rather you say it's clients that the individual actually dealt with in a defined period of time. Usually we say 12 months before the termination. So don't leave that open-ended. Another common one is to carve out any period of time that an employee is on garden leave before they leave the business. So again, it's quite common in the recruitment world when you let somebody go to put them on garden leave because it's a form of restriction. They can't do anything in that period. But make sure that that's reduced from the 6-month restriction, for example. So if they're on garden leave for a month and you've restricted them for 6 months, then they should have 5 months left to run. The courts like to see that carve out. Further good recommendation is not to stop somebody from working in recruitment generally. Again, the courts don't like that because that is a restraint of trade. What you need to ask yourself is, surely it should be specific to the sector. So if you specialise in finance, you shouldn't be stopping somebody working in legal recruitment, for example. It's got to be the sector within which they were involved in your business. And that's where the drafting of the covenants is so, so important. And there's other things around employees can have share ownership in other businesses without that being a breach, and that should be reflected in the drafting. I mean, the key message is that these clauses, lawyers spend hours over these clauses to get them absolutely right, and it's a worthwhile investment to do that at the outset and know that you've got the comfort that when you need to rely on them, they'll be enforceable.
Words matter, you see, especially to us lawyers. We're pedants for wording. But in all seriousness, it's really important. And to give you a practical example of this, a case that I did this time last year, we happened to be acting for the employee. It was a rare situation where we were acting for the employee, but it came to me via a recommendation. So we took it on, and this girl had left her previous employer. The employer claimed that she had been contacting valuable clients in breach of a particular restrictive covenant in her contract. Now, interestingly, the employer didn't apply for an injunction. We'll come on to explain later on why injunctions are the most common means of enforcement. But what they did do is they sued her in the High Court for damages for £250,000. Okay, we managed to get the case struck out against her on the basis of one single word in the restrictive covenant, the word business. The word business, the mistake that the employer's lawyers made when they drafted that clause is that the word business was spelled with a small b rather than a capital B. And what that meant was the entire meaning of that particular provision was ambiguous. It was unclear. And the judge said, I'm sorry, I'm not prepared to accept that that's an enforceable provision because that word doesn't make any sense to me. I don't know what it means. The clause goes. And the practical effect of that, obviously, for my client, she was delighted. She gets to move on with her life. The employer incurred a massive cost liability, not only in respect of their own fees, but they were ordered to pay all of her fees as well, running to, I think, about £50,000–60,000. So it was a costly exercise, and it underlines the importance of drafting.
An example I've got that one of my clients came up with, which was, I can see why he did this, but what he did was he had a non-compete clause in his employment contracts for his staff. And he had the non-compete that would stop the individual from competing for 12 months. And then he replicated the very same clause again, further down in the document, for 9 months. And then he replicated it again for 6 months. And then he replicated it again for 3 months. And what he said to me was, the way I've done it is that if the courts don't like the 12-month restriction, I'll fall back on the 9 months. And if they don't like the 9 months, I'll fall back on the 6 months. And if they don't like that, I'll fall back on 3 months. And so in his mind, he was edging his bets. He was basically saying, I've covered off all scenarios. Unfortunately, the courts would strike that out without any hesitation whatsoever, because what they say is, well, no, what you're doing there is you're not applying your mind specifically to how long you need to restrict somebody. And there's no certainty for the individual there. The individual who's subject to those restrictions doesn't know really whether it's 12, 9, 6 or 3 months. You have to pin your colours to the mast. You have to say, I'm going to restrict the person for this period of time. And as I say, each case is different, and there can be justifications for 3 months, 6 months, 9 months, but you need to know what you're going to go for.
The next question, or the next point that we want to cover, is proving a breach of restrictive covenants. It might sound obvious, but actually it's a fundamental point. And often what happens, and what happens in my experience, is clients pick up the phone and say, so-and-so's contacting clients. And I say, well, what's the evidence of that? Oh, we just know. Well, that's not going to get you where you need to. So it's absolutely critical that you have cogent, clear, preferably documentary evidence that somebody's done something wrong. The classic scenario which comes up all the time is that an email goes astray. And what I mean by that is the employee leaves. Whilst they're with you, they have their Mark Fellowes email address. They leave, they join somewhere else. They then phone up the customer and tap them up for business. That customer then, by way of a follow-up to that call, emails that individual, but accidentally sends the email to the previous email address. And there you pick it up. And that is clear evidence that they've had dealings with that particular client in breach of the restrict covenant. Off you go and get your injunction. I always tell clients that it's important, sometimes in the lead up to the employee leaving, but also immediately after they've left, to interrogate their computer systems. You would be amazed how clumsy some people can be in leaving emails and material on their computer which nails them in terms of having breached their restrictive covenants. Keep an eye on their social media posts. For example, LinkedIn, they update their post to say, I'm now working somewhere where they shouldn't be. They may well be befriending or linking in with somebody who you know is a key client of yours, but also good old-fashioned keeping in touch with your clients. What often happens is employees leave and they think they get on really well with a particular client, so they phone them up. And what they don't realise is that you get on better with that client, and that client then phones you up and says, just to let you know, Joe Bloggs has just phoned me, tapping me up for business. Can you confirm that to me in an email? Yes, of course I can. And there you have your evidence of wrongdoing. So it's absolutely clear, it's absolutely critical that you keep your ear to the ground and you do your homework to find out what the evidence is.
So just to recap, we've talked about the employment contract, the need to have that in place, and we've talked about the need to have very tailored, very well drafted restrictive covenants so that they are enforceable. When you've got to that stage, you'd be forgiven for thinking you're home and dry. Well, you're not, because believe it or not, there is a situation, it commonly arises, where you, the employer, can inadvertently lose the benefit of those restrictions if you do something that amounts to a breach of contract. So the classic example, and it comes up a lot in our world, is the employer who finds out that the employee is doing something wrong, immediately terminates their employment and refuses to pay them what they're due, because they quite understandably say, well, look, this person's out to shaft me. I'm going to make sure that, you know, I punish them in a similar way. And so I won't pay them what their salary is due in the next payroll. I won't pay them their commission. Unfortunately, you need to tread very, very carefully, because if you breach the contract at some point in that sort of period of time, the employee, the ex-employee, has an opportunity to turn around and say to the court, well, I'm no longer bound by these restrictions because my employer is in breach. And so the key message there is, as tempting as it is to want to do something knee-jerk, is to just take a measured approach. It is to take legal advice. It is worth making a phone call to us. It probably would be the best phone call. Yeah, we would say that, but it's the best phone call you can make, because we will say, well, look, hold on doing something too hasty until we can be sure that what you do is going to be lawful. So in some cases, it might still be lawful to terminate with immediate effect because the evidence suggests that. But we'd rather be able to tell you that you're in a position to do that than you do it and then us tell you afterwards, oh, by the way, you've breached. And one of my clients came to me with a situation where he said he's owed £4,000 salary and commission. I know I'm going to suffer loss as a consequence of what this guy's done. I'm going to hold that money back, and that's going to be my compensation for the loss I'm going to suffer. Again, there's case law on that does say that if that's genuinely earned income and commission, if you withhold that, you definitely do run the risk that you breach, and therefore you lose the benefit of the restrictions, and the individual can effectively go off and compete. So, yeah, absolutely.
The next point is so you've got your restrictive covenants in place. Your employees left. You've now got evidence that they've done something wrong. The next question is, what do you do with that? Most of the time, the first thing to do is to write a letter to the employee, setting out what they've done, enclosing a copy of the emails or documentary evidence that you've got against them, and requiring that they give what are called undertakings. This is a fancy lawyer word, effectively, for promises. Promise that you will stop doing what you're doing and abide by the restrictive covenants in your contract. And if you don't give those promises within a very short space of time, we're going to trot off to the High Court and ask a judge to grant an injunction against you, with all the legal costs and risk and so forth that entails. There are some cases where the extent of their wrongdoing is so serious and so blatant that you don't bother with that initial letter. You just prepare your application and you get before a judge and you get your injunction. And some clients phone me up and say, look, I know they're breaching their covenants. I can't prove it, but can you just send a letter to them anyway, threatening them? And I say, well, what's the point in doing that? Because what you're effectively saying, I call them shot across the bows letters, writing a letter to the employee and saying, we know we know that you're up to no good, stop doing it or else. But if you've really got nothing to go on, that's an empty threat and it makes you look weak. The next step then is once you've sent that letter, if they give you the undertakings, great, you've got those in the bank. You then continue to monitor for further breaches of the restrictive covenants. If they don't give the undertakings, you then apply to the court for injunction, and that's quite a hefty process. It involves you working with me and with Mark over the course of a few days to prepare a detailed witness statement, setting out what your case is, why it's important to you that this person is stopped from doing what they're doing for a period of 6 months. And then you then go to court to get your injunction. It's an expensive process, but it is an invaluable process in most cases. And what we normally do before we take that step with you is talk through realistically what you're going to get in terms of value from taking that course of action. And 9 times out of 10, in my experience, clients decide that actually it's well worth their time and their resources taking that action.
Okay, so just to sum up some key takeaways from the discussion today, I think there's 5 that we would probably impress upon you. The first is get that signed employment contract in place. Make sure that's there at the very outset and it's on the system and it's there when you need it most. Secondly, ensure the post-termination restrictions are well drafted and that they're tailored to the circumstances of the individual. So don't just assume in your business you've got a set of restrictions and you just roll those out. Try and think about how they should be tailored to each individual who comes through the door. And as far as I'm concerned, as an employment lawyer, I normally sit with clients and help them on both of those first 2 elements, make sure that contract is absolutely watertight. Third issue to take away is if you suspect there's a breach, get the evidence and be very clever about how you do that. Don't go straight to the employee and ask them about the situation. Think about the methods that you can employ to get information about what they're doing without them knowing it.
And just on that point, there's one point that I forgot to mention, which again we often see, is the employee deletes everything off their computer the day before they go, and they think, haha, I've evaded detection. But actually, most companies these days, and I'm sure that you have these systems in place in your business, everything's backed up, everything's on the cloud. So even if you delete everything off your computer, it's still available. So you can recover information from backups, and hey presto, there's all the detail that you need.
So that's the third key message. 4th key message is particularly in respect of injunctive action, and obviously that's where Barney comes in. Don't delay, because a delay can be fatal to you, and it means you do have to make a fairly informed, quick decision about what you want to do. And there are some clients out there who will say, for commercial reasons, we're not going to do it, and that's fine. But where you're pretty sure you want to take that form of action, you need to move fairly swiftly. And then finally, and again, not wishing to sound like we're selling, but it is, with this particular area of law, it is definitely worth taking professional advice around the restrictions and around what to do when there's a breach, because it's costly if you get it wrong.
It's absolutely critical to get that advice. So I think that's everything we really wanted to cover. I see a few questions have come in, and that's why I've been looking over here, so forgive me. I'm just going to cover off those. The first question that's been raised is, what's to stop the ex-employee from doing deals through someone else to avoid detection? And I think, as I understand that question, I think that question is saying, what if the employee does it via somebody else? They contact clients via somebody else, by which I mean they go along to their new employer and say, here's a list of all the clients that I'm prevented from contacting, but how's about you contact them? The answer to that question usually lies in the wording of a restrictive covenant. We talked about how important it is that you get that right. And invariably, those covenants will say, not only must you, employee, not do it, but you mustn't do it via any third parties. So that would cover the situation where they go to the employer, hand across the client list and say, you get on with it. Now, proving that can sometimes be difficult, but it is the only option available to you in those circumstances. What's the next question? How do I prove I've suffered loss because of breach of covenants? It's an interesting question. In this area of the law, the problem that employers face is that it is very, very difficult to prove the loss that you suffered because